Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. The U.S. Securities and Exchange Commission, SEC, charged Ripple and its officials with violations of securities laws in 2020 for using proceeds from the sale of XRP to finance the company's operations. It said that the blockchain payments business should have filed paperwork to get the asset officially recognized. The prolonged legal struggle has waited for a verdict for almost 2 years. ARK Invest CEO Cathie Wood has shared her thoughts on the verdict. According to her analysis, the SEC is likely to lose the lawsuit. Yet she offers no justification for this assumption. In a recent interview, Wood detailed the SEC's previous court defeats, saying, "It looks that the SEC could be on the road to losing the Ripple lawsuit as well." It's important to note that recent court decisions seem to side with the blockchain payments startup in the ongoing legal struggle. According to the news outlet, Ripple's chief legal officer Stuart Alderoty said the company's confidence increased with each ruling after Daubert motions were dismissed by Judge Annalisa Torres. In addition, Ripple has recently filed letters wherein it cites decisions from other cases that support its fair notice defense. The SEC has apparently answered these letters at long last. The judge in Voyager's bankruptcy case made certain words that were used in Ripple's response, but analysts remarked that the response did nothing to undermine Ripple's claims. As a friend of the court, Attorney John E. Deaton represents thousands of XRP holders in the ongoing legal dispute, and he has informed the community that a verdict on so-called summary judgment is imminent. Wood's recent comments were made in response to questions regarding the feasibility and time frame of a U.S. Bitcoin spot ETF being authorized by the Securities and Exchange Commission. Using quotes from judges in the Grayscale appeal, the head of ARK Invest criticized the commission for being inconsistent in their approval of Bitcoin ETF products. As was mentioned in a prior piece, courts questioned the SEC's rationale for approving a futures ETF, but rejecting a spot ETF despite both having similar fraud safeguards. As a result, Wood believes that Grayscale will get a favorable verdict in June. She said the SEC would have to decide between rescinding its approval of the Bitcoin futures product or allowing the Grayscale spot ETF. You may recall that Wood's ARK Invest, in conjunction with 21 shares, has twice filed an application for a Bitcoin spot. The SEC has twice denied the offering, most recently in January. The excitement around the result of the Ripple versus SEC litigation has reached fever pitch. Several members of the XRP community had counted on pro-XRP lawyer James K. Filon's forecast that Judge Annalisa Torres' judgment would arrive before the end of March. Unfortunately, his prognosis did not come true, leaving XRP investors perplexed, with many XRP fans wondering why Judge Torres didn't rule yesterday. Crypto law founding attorney John Deaton identified the few insiders who may know the precise date of the judgment. According to Deaton, only Judge Torres' staff and the court clerk would be aware of the Ripple V's SEC judgment date. The only individuals who will know before the judge publicly publishes her verdict are her staff and any clerks who assisted her with research or decision-making, Deaton added. His most recent statement is in reaction to XRP aficionados who think Ripple and SEC executives will be aware of the date. It's worth noting that Deaton's statement came only hours after he anticipated that Judge Torres' decision may take up to 60 days. Notably, numerous XRP supporters were disappointed when Judge Torres did not make a judgment yesterday, March 31, as Filan projected. In response to a remark on the matter, Deaton explained that the deadline for Judge Torres to grant summary judgment was not yesterday. He indicated that Judge Torres might rule within the hour or opt to disclose the decision during the following 2 months. According to Deaton's past cases, Judge Torres normally gives summary judgment a few months after evaluating Daubert's motions. It is worth noting that Deaton is heavily engaged in the litigation, acting as an amicus curiae for members of the XRP community. Friend of the court. Deaton expects that, as amici curiae, Judge Torres will rule in favor of XRP holders by finding that the coin's secondary market transactions do not constitute a security. Deaton listed 4 potential litigation outcomes that might benefit XRP investors yesterday. Deaton believes that Judge Torres will decide that XRP secondary market transactions are not securities in all 4 scenarios. But if Judge Torres awards a summary judgment in favor of the SEC and fails to remark on XRP, Deaton said he would try to get the court to define the crypto asset, as he did in the Learbry case. The blockchain company Ripple and the Securities and Exchange Commission, SEC, seem to be nearing the end of their legal battle, according to a growing consensus in the cryptocurrency world. The case's resolution is widely anticipated to affect the future course of crypto market regulation, particularly with regard to securities categorization. As of March 27, a tweet from pro-Ripple attorney John Deaton predicted that a decision will be issued by the court within the next several weeks. If not this week, Deaton claims there is nothing to lose for XRP even if the SEC prevails since the coin offers the best risk-reward. But he said that if Ripple prevails, the fact that XRP is not a security would be established, and the token's value will rise. According to Fox Business, attorneys involved in the case have hinted that the legal conflict might terminate in the next days, thus increasing the likelihood of the summary judgment date. Deaton has encouraged the crypto community to see the lawsuit as an assault on the whole digital asset market and not just a Ripple problem, since he expects the contentious Heinemann speech emails will be opened on the basis of being judicial records. On March 23, defense attorney James Phelan tweeted that the SEC had sent its answer to the defendants in Ripple's letters requesting permission to rely on Bittner and Voyager as additional authority. According to the SEC's reaction, the letter included random thoughts, excerpts from the judge's concurring judgment in the Bittner case, and an order confirming the bankruptcy plan in the Voyager case. However, the regulator said that the extracts do not give any grounds to reject the SEC's move for summary judgment, despite the defendants' claims that they bolster their fair notice position. The SEC's answer to the Bittner case raises some fair concerns, Ripple supporter and lawyer Jeremy Hogan argues. But the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto realm is smirkable. The answer, he said, renders the Bittner judgment moot, but the Voyager judge's judgment is still in effect for Ripple. Both sides are convinced they will prevail in court, so a settlement is a significant development. Bill Morgan, an attorney from Australia, said that all chance of a settlement was eliminated after seeing the CESA's response letter